Cargill and San Fernando are sellers and buyers of molasses under the contract. It was agreed that San Fernando would purchase 12,000 metric tons of Thailand origin cane blackstrap molasses at a certain price. Cargill, however, failed to deliver the ordered molasses to San Fernando. Thus, San Fernando filed a complaint for rescission of contract with damages before the RTC to dismiss or suspend the proceedings and to refer the controversy to voluntary arbitration pursuant to the arbitration clause. It alleged that the contract was never consummated because San Fernando did not return the proposed agreement, varying its written acceptance and conformity. The controversy being the existence of contract, it argued that the RTC was not the proper forum but by an arbitration proceeding before the American Arbitration Association.
San Fernando opposed. It argued that RTC has jurisdiction over the action for rescission of contract and could not be changed by the arbitration clause. RTC denied the motion to dismiss and directed Cargill to file answer. Cargill filed a petition for certiorari with the CA. CA denied the petition and affirmed RTC's orders. It held that the case cannot be brought under the arbitration law for the purpose of suspending the proceedings before the RTC, and it was proper that the issue on the validity of the contract and the arbitration clause be resolved first. Arbitration is not proper when one of the parties repudiated the existence or validity of the contract. Whether the CA erred in finding that this case cannot be brought under the arbitration law for the purpose of suspending the proceedings in the RTC.
The petition is meritorious. Civil law, arbitration, alternative dispute resolution. Contracts arbitration, as an alternative mode of settling disputes, has long been recognized and accepted in our jurisdiction. Republic Act No. 876 authorizes arbitration of domestic disputes. Foreign arbitration, as a system of settling commercial disputes of an international character, is likewise recognized. The enactment of Republic Act 9285 on April 2, 2004 further institutionalized the use of alternative dispute resolution systems, including the arbitration, in the settlement of disputes. A contract is required for arbitration to take place to be binding. Submission to arbitration is a contract and a clause in a contract providing that all matters in dispute between the parties shall be referred to arbitration is a contract. The provision to submit to arbitration any dispute arising therefrom and the relationship of the parties is part of the contract and is itself a contract. The validity of the contract containing the agreement to submit to arbitration does not affect the applicability of the arbitration clause itself. A contrary ruling would suggest that a party's mere repudiation of the main contract is sufficient to avoid arbitration. That is exactly the situation that the separability doctrine, as well as the jurisprudence applying it, seeks to avoid. The petition is granted.